The newest member of the Commission on Ethics, Mr. Joshua Hawks. Joshua, you're under no obligation to speak, but we'd invite you to if you'd like to say anything. It's your inauguration.
Yeah, my name's Joshua Hawks. I've lived in Tallahassee since 2011. I have 5 kids, and I'm also a Navy reservist, and I work over here at Foley and Lardner downtown.
It's nice to have you. I had the pleasure of sitting next to Mr. Hawks last night at dinner, and across from my colleague, Mr. Norris, who, for those of you who weren't there, should know that he, at the beginning of the dinner, ordered a cocktail, and the waitress bought him a big bowl of shrimp cocktail. And we think it's the way he talks.
Clearly.
This would be a good opportunity, since it's July, for me to entertain a motion to select our new chair and vice chair. We can do that separately or together. After, I was so excited about doing that I forgot to call the roll. Here.
Present.
Here. Here.
Here.
Here. Thank you. Let's say the Pledge of Allegiance. Commissioner Brady, would you lead us, please?
Pledge allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Anything else anybody wants to do before I hand this over? All right, sorry for jumping the gun in my excitement. At this time, I would entertain a motion to elect a new chair and/or vice chair. We can do it separately or collectively. Commissioner Berger?
Yeah, I would like the honor of making the motion to appoint Commissioner Norris as chair and Commissioner Rozenka as vice chair.
There's a motion. Is there a second?
I'll second the motion.
There's a motion and a second. Any discussion? I have a lot, but since I'm still the chair, I'm going to withhold my comments. They will both serve very well. We look forward to having them as our leaders. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed?
Nay.
Awesome. That was about to switch places.
All right. Get your tag, too. Okay. Well, since I do not know what I'm doing, we will commence. I think our first order of business is to congratulate and thank our outgoing chair, Ms. Anchors, Commissioner Anchors, who has served on the board for a year or two and has earned many different accolades and monikers, such as the skeptical commissioner, and now I understand from now on it will be the no plaque chairman, as she has denied me the opportunity to hand over a plaque on behalf of the commission to express our appreciation for your great service. And it was great service. You have truly helped us to move our commission meetings along not only fairly, but timely, and that is greatly appreciated by all, and just done a terrific job. So we thank you and wish you all the best in all your future endeavors.
Thank you.
Thank you very much. All right, and my friend, Commissioner Rozenka, I look forward to working with you as well as our vice chair. That'll be awfully fun. Go back to our college days, and that's great talk for dinner. So if any of you who, you may ought to come to the dinners on Thursday evening. They're a treat, to say the least. Lots of laughs. Okay, so we have the next thing on our agenda is a consideration of the June 8, 2018 public meeting session minutes.
Move to approve. Second.
We have a motion and a second. Any discussion? Seeing none, all in favor?
Aye.
Any opposed? Thank you. All right, the first matter, okay, now I'm messing up the, what'd you do to the computer here? It moves, the chair's cursed, my computer's moving at a full page, okay. All right, consideration of final action, reconsideration of penalty on remand. This is complaint number 14167, in Ray Robert K. Robinson. Ms. Miller is our advocate on the matter. Mr. Herron, I believe, is here on behalf of the respondent. Is there anyone else present for this matter? Welcome, our complainant. Madam Complainant, will you please state your name for the record?
Yes, my name is Connie Bruni, Englewood, Florida.
Thank you, Ms. Bruni. Welcome. Glad to have you here today. All right, Ms. Miller, I believe you have 10 minutes. Are you ready?
Thank you. Yes, sir. Thank you.
Please proceed.
Thank you. Good morning, Commissioners. I'm Elizabeth Miller, advocate for the Commission. Commissioners, this case is once again before you after having been appealed by the respondent to the First District Court of Appeal and now on remand by the First District Court of Appeal to recommend a penalty. I am simply asking you to recommend the same penalty that you deemed appropriate over a year ago. That is a $5,000 monetary civil penalty and a reprimand or public censure and reprimand. Since your previous recommendation, nothing additional in the record supports mitigation or a reduction of the penalty that you deemed appropriate over a year ago. In fact, the record is even stronger. The First District Court of Appeal, in a 2-to-1 decision, affirmed the administrative law judge's finding and your final order finding that the respondent misused his public position. That finding of misconduct for a misuse of public position was conclusive. The First District Court of Appeal rejected the respondent's narrative that he was simply acting as a faithful public servant motivated by his best intentions. Instead, the court accepted this commission's narrative or position that the respondent's corrupt act was motivated by the respondent's pecuniary self-interest in preserving a position or a stream of income from the city that he had enjoyed for about 13 years. In other words, the respondent wanted to continue to feed from the public trough. So he did that by creating 2 public positions, both quasi-judicial positions. And he created a situation before the city commission where he had to be appointed to the exclusion of all other potential candidates. He got himself appointed to those 2 positions to continue to receive a city paycheck. The court said that the respondent knew, or he should have known, that his actions were wrong and unethical. This was a violation in which the respondent had to orchestrate, manipulate, and deceive to carry out his plan. The penalty that you recommended previously, and I'm asking you to recommend again today, is fair to society, it's fair to the defendant, and it's severe enough to deter others who may be tempted to become involved in similar violations. Also, it complies with the law. Importantly, the penalty comports with the penalties that this commission has recommended in other similar cases where corruption was an element. Again, I respectfully ask you to recommend the penalty that you previously recommended after much consideration of this matter and after reading the record, and that is a $5,000 civil penalty for the 1 remaining violation of misuse of public position and a public censure and reprimand. Thank you very much.
Members, do you have any questions? I have a couple of questions for you, Ms. Miller. Let me ask you this. This case precedes my service on the commission as far as when it came up for probable cause. And I see that it was a close case on the probable cause determination. And then the appellate court has affirmed one of 4 counts that were brought against this respondent, right? There were 4 probable cause determinations, I believe, and then the administrative law judge, the ALJ, found in favor of the commission on 2.
Correct, there were 2, yes, sir.
And then the appellate court has sustained one of those 2, correct?
Yes, sir.
And that is in a divided opinion, right?
Yes, sir, 2 to 1, yes.
The dissent. I noticed that both the majority says we can look at this case 2 ways, and then the dissent says no good deed goes unpunished. What do you think is the message that is being sent to us by the appellate court with respect to this particular case and the sanction?
I think the message is exactly what the decision says, that he, Mr. Robinson, violated the ethical code by misusing his public position. And he violated a subsection 6, which is the misuse of public position. In doing so, he acted corruptly.
At the administrative law hearing before the ALJ, the commission asked for the reprimand and the censure as sanctions?
Yes, the administrative law judge did not recommend public censure, and in exceptions, I asked for public censure and reprimand, and the commission did recommend it, yes, sir.
Yes, but my question is, did you ask for it also before the administrative law judge?
Yes, sir.
Okay, all right, thank you.
Thank you.
Any other questions for Ms. Miller? All right, thank you for your
Thank you.
indulgence. Me, Mr. Herron, welcome. You have 10 minutes, sir.
Thank you, Mr. Chairman. Good morning, members of the commission. I'm Mark Herron on behalf of Robert K. Robinson in this proceeding. As we argued at the formal administrative hearing and in our recommended order and in our exceptions to the recommended order and in our appeal, Robinson believes that no finding of violation is appropriate, nor is any penalty appropriate. We recognize that the administrative law judge found a violation of 2 statutes. We also recognize that the court found a violation of one of the statutes, 112.3136, and remanded this case here for determination of the appropriate penalty. We also believe that the NOAA penalty is appropriate, and I will try to explain why. As your chairman, your new chairman, congratulations, Mr. Chairman. As your new chairman, and condolences, as your new chairman just pointed out, this is almost like the case of losing by 1 vote all along the way. The probable cause finding in this case was 5-4, way back when, and the decision of the appellate court was 2-1. The factual record in this case indicates that all actions taken by Mr. Robinson in this case were taken in public view. They were debated and approved by the City Council, the City Commission, all along. There was a dissent of one commissioner, and a citizen has brought this complaint as a result of disagreements with the actions taken. We also have argued that the actions of Mr. Robinson did not adversely affect the city. Now, why do we believe that no penalty is appropriate in this case? If you read the dissent carefully, and you read the opinion of the administrative law judge, this case turns on what supposedly are the best practices that Mr. Robinson should have done. And I'm going to read to you, again, I'm not going to argue things, I'm going to read to you paragraph 81 of the recommended order. Except for his involvement in the development of 2 ordinances relating to the zoning hearing officer and special magistrate, Nothing in the record suggests that respondent ever provided less than exemplary legal services to the city. Based upon his years of services to the city and based upon the fact that respondent generally had the majority of the commission on his side when he made recommendations for actions to be taken, respondent's recommendations with respect to the city commission hiring him both as the zoning hearing officer and the special magistrate put him in an advantageous position with respect to securing these two contracts. Except by Commissioner Yates, who appeared to be generally critical of respondent, respondent was a trusted and presumably well-respected city attorney or attorney for the city. A prudent action for respondent to have taken when the ordinances came before the city commission would have been to inform the city commission it should contract with an outside attorney to handle the discussions and ultimately negotiations that led to respondent securing both positions. Even more prudent would have been a suggestion by respondent that the city commission engage the services of an outside attorney throughout the development of the two positions described by the ordinances once he knew he intended to apply for one or both of them. Had the city commission voted not to engage outside services, even with the knowledge respondent would be applying for one or both of the positions, respondents would have covered himself by avoiding any conflicts or appearance of impropriety through full and open disclosure. By proceeding with ordinances at the meeting while he was still under contract as the city attorney, respondent left the clear impression that he had a personal pecuniary interest in the outcome of the vote of the two ordinances. By offering his services at the 11th hour as the best qualified candidate for the hearing officer position, the obvious conclusion an outsider to the process would make is that respondent created an unfair advantage for himself and his firm. As noted by Judge Makar in his dissent, the significant issue here is whether respondent acted corruptly. Again, those findings have been made by this commission, the administrative law judge, and the court. But the question is, did he have reasonable notice at the time that the best practices that he should have followed were in fact the law? Judge Makar suggests that he did not. We would suggest to the commission that in this case, a finding of violation, again, which cannot be reviewed at this point in time, but the appropriate penalty here would be perhaps just a finding of violation, and that would make the point to Mr. Robinson as well as to any other individuals that there is issues in these kind of contexts. And we'd suggest that no monetary penalty be imposed, nor any public censure or reprimand.
Thank you, Mr. Herron. Any questions for Mr. Herron?
And the objection to the penalties is it's really not related to the gravity of the offense?
I think that really relates to the fact that it's a very, very close call. It's based upon best practices that weren't, as Judge Makar points out in his dissent, open and obvious to a city attorney in that position at that time. Now it is because of the court case.
Any other questions from the commissioners? Ms. Herron, I have a question for you, similar to the one I asked Ms. Miller. And, you know, and I don't like my question much in a way because I think that it calls for speculation on the part of the court. But what is your understanding as to why did the court, given that it sustained one of the counts, if you will, one of the charges, why didn't it simply sustain the penalty for that and instead remand the matter with respect to the entire penalty, in your view?
Well, I think they did remand it with respect to the entire penalty with respect to 112.3136. I mean, that's what they did. Why they just didn't affirm and say, hey, the $5,000 you impose with respect to 112.3136 is, you know, just affirm that violation and penalty, I do not know. I think perhaps because of the language in the majority as well as the dissenting opinions, that I think the court, and again, this is total speculation, may have been saying to this commission, this is really, really a close case, and a penalty may not be appropriate here other than the finding of the violation. But again, that's me saying for my side, and I mean, it's just totally gross speculation. We're in their building. It's a shame we can't ask them.
Yes. Yes, wouldn't we all like to? Okay. Any other questions for Mr. Herrick? All right, seeing none. Members, is there a motion on whether to adopt the staff draft order? Commissioner Bergen.
To adopt the recommendation of the staff.
Second.
Okay, we have a motion to adopt the recommendation and a second by Commissioner Rosanka. Any discussion? Yes, Commissioner Braden.
What is the, no, that's probably to the staff, what is the practical outcome of a reprimand and censure?
So that, Commissioner Brady, typically the governor imposes a public censure and reprimand in his executive order where he also imposes the penalty of the fine. So the executive order, instead of saying hereby imposed a fine of $5,000, would also say imposed a fine of $5,000 and public censure and reprimand. That's the means by which the public censure and reprimand is generally effectuated.
But as are there consequences in terms of the bar? Are there consequences beyond the fact of basically being subjected to a censure and reprimand?
There may or may not. I don't know the answer to that, and that's not part of the record.
Oh, okay.
Sorry. Any other discussion? All right.
Just, can I?
Yes,
one-
Commissioner
This is
Anker says.
almost out of sympathy, but I think it continues to be close in the same way that it has been from the probable cause stage through the court's consideration of this, continuing to notice that it's close. I still think it's close today, but after you've had this many renditions of facts and law by an administrative law judge and by a court of appeal, it provides me enough material to support the draft recommended order, remaining skeptical. Difficult, but I think there's enough there that has given me the justification that I need from people probably way wiser and way smarter on this close issue. So I'll support the motion.
Any other discussion? Seeing none, we will call for the vote. All in favor of the staff draft order and the motion, please say aye. Aye. Any opposed? Motion carries. All right, the next matter is our agenda item 6A, consideration of final action on a recommended order. This case involves Kashamba L. Miller Anderson, case number 2017-80. We have before us the recommended order of the administrative law judge for the Division of Administrative Hearings in this case. This is a statutorily mandated complaint to determine whether the respondent's failure to file financial disclosure was willful. The administrative law judge found the failure not willful and has recommended the matter be dismissed. Will the parties or their counsel please identify themselves for the record?
Melody Hadley, Commission Advocate.
Good morning, Mr. Chairman. My name is Ron Meyer. I'm on behalf of the respondent.
Welcome, Mr. Meyer. The advocate filed written exceptions to the administrative law judge's recommended order, which do not alter the ultimate recommendation of dismissal, but do ask us to modify certain conclusions of law. The respondent filed no exceptions, but did timely respond to the advocate's exceptions. We have copies of the exceptions, the response thereto, the record, and a draft final order recommended by our commission staff, which accepts the advocate's exceptions. Ms. Hadley, are you ready to proceed?
I am.
All right. You will each be given 15 minutes for argument. The advocate will argue her exceptions first, then the respondent will reply. The advocate may have rebuttal if she saves time to do so. commission members are free to ask questions at any time. Then we will have discussion, questions of staff, if any, and a motion on adoption of the staff's draft order. Under the Administrative Procedures Act, we are able to reject or modify a finding of fact, or we're not able to reject or modify a finding of fact unless the commission determines that there is no competent substantial evidence to support the finding. And if we reject or modify a conclusion of law, we must find that our substituted conclusion of law is as reasonable or more reasonable than the administrative law judges. So, Ms. Hadley, if you will, please proceed with our...
May I have 5 minutes of rebuttal time, please?
Yes.
On October 25th, 2017, this commission issued an order finding probable cause to believe that the respondent, as a member of the Riviera Beach City Council, violated Section 112.3148, paragraph 8C, by willfully failing or refusing to file an annual CE Form 1 Statement of Financial Interest for the year 2015. On June 7, 2018, the ALJ Administrative Law Judge issued a recommended order recommending that the commission find no violation of that particular section. The basis of the ALJ's recommendation was premised on 2 factors. One factor was whether a violation of this section requires that the financial disclosure form not be filed at all. The second factor was whether respondent's failure to timely file was willful. I contend that the ALJ misinterpreted the statute to mean that a violation of the statute requires that the respondent must have failed to file her 2015 financial disclosure form at all, and disregarded that the respondent's filing was not timely filed, which triggered the commission's investigation into whether the failure to file was willful. I also contend that the administrative law judge used the incorrect definition of willful for the statute, and thus I filed 2 exceptions. Exception 1. Under Exception 1, I request that the commission revise paragraph 34, strike paragraphs 35, 36, 37, strike paragraph 38 in part, strike and amend paragraph 40 in part respectively, and amend the final recommendation. By statute, the 2015 financial disclosure form was due on July 1st, 2016. There was a grace period to file which ended on September 1st, 2016. After the grace period ended, a $25 pay per day fine accrued thereafter for up to 60 days with a maximum fine of $1,500. The maximum fine of $1,500 is based on $25 a day times 60, with the 60th day occurring on October 31st, 2016, Pursuant to the statute, once the maximum fine accrued, the Commission on Ethics is required to initiate an investigation into whether the filer's failure to file by the maximum accrual date was willful when the following conditions occur. 1, that the filer holds public office or public employment, and 2, the filer received notice from the Commission regarding the failure to file. The investigation is triggered regardless of whether that $1,500 fine is paid or not. Thus, if the filer fails to file by the maximum accrual date, then that is the date to determine if the violation is willful. After maximum fine is accrued, there was no way to cure the defect of not timely filing the exception, except with the filing of a successful appeal, to which the respondent in this case did not avail herself. Respondent did ultimately file her form in June 2017, which is almost 12 months after it was timely due. Respondent's late filing of her 2015 form in June 2017 does not negate her violation of the statute. It is improbable that the legislature intended that a violator could circumvent this law by potentially filing a year or even later. That in itself shows that the legislature intended the Commission to pursue violators of this law once the maximum fine accrued, regardless of later actions by the violator. On June 13, 2018, the Commission entered a final order and public report in the Joel Davis case, which applied similar facts to this particular statute. In the Davis case, respondent did not timely file his financial disclosure, although he did file it subsequently. The final order recognizes that late filing has no bearing on whether the respondent's willfulness in violation of the statute, just as paying the $1,500 has no bearing on the respondent's violation of the statute. If a filer fails to timely file the form, while she is subject to the $25 day fine, she is also subject to someone filing a complaint, which can lead to multiple penalties, including public censure and reprimand, and a $10,000 fine. If the commission adopts the ALJ's theory, then it's one, contrary to your prior order, and two, allows someone to file at the last second, including at hearing, which defeats the law and your order finding probable cause. Exception 2. Under Exception 2, I request that the commission strike and amend paragraph 39. In this case, the definition used by the ALJ for willful is inappropriate for a general intent statute and contrary to the commission's standard established for willful in the Davis case. In the final order in Davis, the commission adopted the ALJ's definition, which is gross indifference and reckless disregard to the requirements of law. The language in section 112 through 145 indicates that it's a general intent violation. The absence of language encompassing a subjective intent indicates that it is a general intent statute as opposed to a specific intent statute. The legislature has not defined the word willful in the purview of the Code of Ethics in filing the CE Form 1, and thus with construing an undefined term, we must look at the common or usual meaning of the term. Under these circumstances, the First District approved the Florida Elections Commission to employ the case law definition of reckless disregard. Therefore, a willful violation is a knowing violation or a reckless violation. However, even with the change in definition for willful, the final determination that respondent's conduct was not willful must stand. While the ultimate finding of fact regarding willfulness cannot be disturbed, the issue regarding the timeliness of the filing of the financial disclosure form and the definition of willful must be addressed. I respectfully request the commission accept that amended conclusions of law and definition for willful are as or more reasonable than those found in the recommended order. Thank you.
Thank you. Any questions for Ms. Haddle? Commissioner Berger.
Yes, I'll ask a more of a big picture question here. So, facts are not going to change. The respondent was found not in violation. And the big picture is that there's a concern that there's going to be more precedent set as far as the opinion that was written.
Well, you have an issue where you're going to have contrary rulings because you've already ruled on this issue in the prior Davis case.
Commissioner Brady.
Just so, as a non-attorney, just so I understand it, the basic concern is that if you ever fall out at any point in time, you kind of no longer have willingly not filed. I mean, that's what I got when I read all of this, was that a year from now, I said, yeah, I know I should have filed last year, but gee whiz, I'm busy and it's not important. But I guess if you're really going to beat me up, I'll go ahead and file now.
And honestly, that could happen, which someone could wait till the day of hearing and file and totally disregard the law. And if you follow this, then it may end up happening at hearing that the case be dismissed because someone waited years later to file, which defeats the purpose of the law.
Because the idea is that, well, if I did it, I must have intended to do it. I just didn't get around to doing it. Okay,
Thank
never
you.
mind.
Any other questions for Ms. Haddle? Seeing none. Mr. Myers.
Good morning, Commissioners. My name is Ron Meyer. I'm here on behalf of the respondent. And, I understand when the outcome is going to be the same no matter what the decision you make today on the exceptions is. That is, the petition is going to be dismissed because of the finding that there was no willful violation under any of the standards. One might ask, well, why are you even here? And the reason we're here is because we feel there's some important issues of law that don't have the opportunity for review after we leave here because we've won. In other words, there's no appeal that's going to come from your order here. Ms. Miller-Anderson is going to have been found not to have violated the statute, and the case is dismissed. So this is the only opportunity that these legal issues get to be vetted, and we believe they are important legal issues. Let's take exception number 1 first. Ms. Hadley, and indeed your own staff attorney, seek to rewrite what the Florida legislature wrote. It may be very desirable from the part of this commission to say that chronic late filing of a report or extremely late filing of a report should result in removal from office. That may be an excellent public policy for this state, but that's not what the legislature did, and that's where this question belongs, not here in an interpretation of legal statute. The statute is clear. You have 112.3145(7)F, which imposes a fine. And why does it impose a fine? It imposes a fine because the filing of the report is late. $25 a day, $1,500. Ms. Miller Anderson paid it. She didn't like paying it. She was punished. As the record reflects, she had some misunderstanding. She thought she had to pay the fine before she could even late file the report. That was wrong, but that was an honest belief, as the hearing officer found, and that's why the report was even later than it might otherwise have been. You got her attention with a $1,500 fine, and she didn't understand that it would have been smart to come here and appeal that fine. But the point is, the statute creates the fine. There may be other penalties that the statute would also tolerate. Somebody might file a complaint, and you would have different jurisdiction. But the point is, we're operating on this record under one statute that says you got the auto fine. Well, what's the second part of the statute? Second part is 112.3145(8)C. That says, and I'm quoting, if a person holding public office or public employment fails or refuses to file an annual statement. And then it goes on to determine later that the commission can determine that the person willfully failed to file a statement of financial interest. I don't know how you could say it any more clearly. If you don't file it, you're subject to a finding by this commission that you are going to come through this process to determine whether you didn't file it willfully, or was it an accident or a mistake or something else. But it's not because you filed it late, it's because you didn't file it. And that's what the statute says. What the advocate, what your general counsel asks you to do is add words to that statute to suggest that the failure to file or the refusal to file includes the refusal to timely file. And the legislature certainly could have said that, and maybe should say that. But the point is, it hasn't said that. What's the court say? Courts should give statutory language its plain and ordinary meaning and may not add words that were not included in the legislature. If the statute's plain language is clear and unambiguous, courts should rely on the words used in the statute without involving rules of construction or speculating as to the legislature's intent. Not only should courts do that, administrative agencies that are acting in a judicial capacity should do that as well. And so my point here is simply this. We're operating under a framework of law that says when you don't file on time, you're susceptible of getting a fine. She didn't file on time. She was fined. She paid the fine. It says also, if you fail and refuse, and the record will show that the testimony of the commission's own staff is that sometimes people don't file at all, never file the report. That's what this second section of the statute deals with. It says a person who fails or refuses to file the annual statement is susceptible of the proceeding we're now in. So my point is, on exception 1, it should be rejected, notwithstanding your able general counsel's recommendation in the proposed order he has supplied to you, notwithstanding my able colleague, Ms. Hadley's argument to the contrary. The law just doesn't support it. You don't get to rewrite the law. The law is unambiguous, and therefore, exception 1 should be rejected. With respect to exception 2, it's conceded all over the place. Ms. Hadley told you this morning, legislature hasn't defined what willful is. There's no statute that says if you do this, 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 and this, you're acting willfully. The whole case that we are involved in today is limited to really one issue. Did the respondent in this case willfully fail or refuse to file an annual report? Well, we've already established she did file an annual report. So the question then becomes, well, whether was her chronically late, I think the administrative law judge used the word woefully late, was her woefully late filing of the report willful? Well, there's not a scintilla of evidence in the record. I defy you to find it. No witness testified that this woman had a conscious, evil, intentional purpose not to file the report. Record's full of evidence that she was careless, it got lost on her desk, she didn't attach importance to it. She knew she had to file it. She had filed one the year before, she filed one the year after. This one, her first as an elected officer, got lost in the shuffle. Was that smart? Of course not. Was it wise? Of course not. But did she willfully not do it? The answer is no. There's no evidence to suggest a willful refusal to do it. It was stupid, it was mistaken, it was careless, and all the administrative law judge found was the case law requires more than that, citing cases that, quote, a willful act is one done intentionally, knowingly, and purposely without justifiable excuse, as distinguished from an act done carelessly, thoughtlessly, heedlessly, or inadvertently. That's Patterson v. Florida, First District Court of Appeal decision cited in my response. You don't act willfully when you make a mistake, when you're careless. And my point is the administrative law judge applied the correct legal standard as this court, the First District Court of Appeal, has repeatedly imposed on cases of this type, which are penal in nature. This woman stood the risk, if found to have acted willfully, of being removed from her office. That's the penalty. There's no other fine. If she acted willfully, your recommendation is to the governor to take her out of office. That's a penal statute, and it requires a far higher degree of proof in our estimation than mere carelessness or chronic lateness or even stupidity. It requires some conscious intention not to do something that the law says you should do. That's not the facts here. There's nothing in the record, not from the commission's witnesses, not from the respondent, that suggests that was what happened here. So, I'll end here. We believe that the correct legal standard was applied by the administrative law judge. We believe that exception number 2 is not well taken. We believe that since there is no statutory definition of willful, we have to look at what the courts have said as well as what you've said. But in this case, the administrative law judge found that the actions of this respondent were not willful because they were not done intentionally, knowingly, and purposely without justifiable excuse. I end by simply asking you to affirm what the administrative law judge did. Adopt the administrative law judge's order. It's well thought out, it's thoughtful, it correctly reads the statutes that are involved here, and it applies a correct legal standard for willfulness as decreed by the First District Court of Appeal. Thank you very much.
Thank you, Mr. Meyer. Any questions for Mr. Meyer?
I have questions.
Mr. Brady.
I somewhat misunderstand the issue of willingness. If I run a red light, and I had no intention of running the red light, I really just wasn't paying attention, and when I get pulled over and give a ticket, and I say, you know, if I saw it, I would have stopped, but, you know, I just wasn't paying attention, and it wasn't intentional, and, you know, so, you know, just let me go. Is that a totally mistaken kind of analogy?
No, but I don't think you'll find court cases that say that to violate a traffic law requires a specific intent, as you have here, where you have a statute that says you're going to be removed from office if you did something willfully. And we have cases that define under those circumstances where the penalty is so harsh, what willful is. No, I think it may be mitigation that a court may take into account that, you know, I didn't see the light, as opposed to, by God, I'm going to run every red light that I see. But you're right. It's not an answer to say that I didn't mean to run the red light.
So the concern has a greater relationship to the penalty than it actually has to intent. If the penalty was not removal from office, then there might be a different standard for willingly.
I think there may be a different degree of consideration that has to be given to what is a willful violation. Here, we're operating under a penal statute with a serious consequence, and the court has said it takes more than negligence to be willful.
Thank you.
Commissioner Rosenka.
Mr. Meyer, the administrative law judge, the advocate, and you all cite the Fugate case, and they all cite it differently. Does the Fugate case adopt the reckless disregard standard?
I think that can be read to say reckless disregard is a factor. It's not particularly relevant here because I don't think the administrative law judge, as a matter of fact-finding, didn't find the facts rose to that occasion, so she didn't have to get to that standard.
I don't think she ever mentioned reckless disregard. That's why I bring it up, because I have not read the case, and I probably should have. That's all I have. Thank you.
Any other questions for Mr. Meyer?
Thank you,
Mr.
Commissioner.
Myers. Ms. Hadley, your rebuttal.
You know, listening to Counsel Meyer, it's like everything he said actually sounds a little willful surrounding the respondent's circumstances. She received notice and she didn't file. However, as noted, we are not here to change the ultimate fact. What we are here is to continue with your prior ruling in Davis. And with that being said, your prior ruling should stand. You've already ruled on that the person, even if the person files later, that it doesn't matter, that we're still supposed to proceed. You've already ruled on what the definition of willful is, and we should proceed with that. In Valles v. Commission, the court held that an agency is afforded wide discretion in the interpretation of the statute, which it is given power and duty to administer. You've made a ruling in Davis on what the definition of willful is, and again, that it doesn't matter if someone subsequently files a form after the commission has to initiate the investigation. And as I stated earlier, there are multiple sanctions that can be assessed against a filer. Just because the $25 a day fine isn't the only violation or sanction that can be assessed against a filer for failing to timely file. So I don't agree, I respectfully don't agree, that just because you get that fine, that also means that someone couldn't file a complaint against you for failure to timely file. So there isn't only one sanction that goes for someone who fails to timely file and one sanction that goes against someone who doesn't file at all. So with that being said, I stand on my written arguments and on my oral arguments.
Yes.
Ms. Hadley, if we did not accept your first exception and did accept your second exception, can you describe to me the outcome of that? Does that cause chaos? It does allow us to remain consistent with Davis, if I understand it.
Actually not, because Davis, in that particular case, Mr. Davis failed to timely file, but he did subsequently file before the hearing. So I'll rephrase. Okay, in Davis, it's the exact same circumstances. He didn't file on time, which triggered the investigation, but he subsequently filed. So you have the same, you've already made a ruling that it doesn't matter if someone subsequently files, that we would still proceed. That's what happened in Davis.
I'm just going to express a little bit of an opinion that may or may not affect my ultimate vote, and if you have a response to it, then I welcome it. I feel like the ruling on the advocate's exceptions in our draft final order in paragraph 1, I feel like we're doing a lot of justifying that says there is language or some double negatives. That's probably partly why I'm concerned about it, but it feels to me like we're working really hard to justify a reason to get around the ALJ's recommendation in that. But you don't, that's not really a question, Ms. Hadley. It's more just my observation. So if you have any comment on it, you're welcome to make it, but I also don't think it was posed fairly as a question for you to have to answer.
Well, I guess that's just a part of doing the analysis. We have to try and prove why we think we're right. So I think it's more, I suggest it's more of an analysis than trying to get around the ALJ's ruling. I think it's just a thorough analysis of why it should be ruled in this manner.
Any other questions?
I'm
Commissioner
actually
Rosenko.
confused about exception 1 where it says paragraph 37 should be, it says in paragraph 38, you leave the evidence did not demonstrate that the late filing was willful. And you don't strike that part.
This is contingent on, as we stated earlier, even if you change the definition of willful, it can't change the ultimate fact, so that's why it remains the same.
Any other questions from Ms. Hadley? I have one. Ms. Hadley, I'd like you to, as I understand sort of the respondent's argument, it's that, the administrative law judge made their finding and issued the penalty, and the penalty was paid, and that's the end of the case. Why is that wrong?
I'm sorry, you said who issued a finding and the penalty was
That
paid?
the ALJ issued the finding that that it was not willful.
Okay.
But there's no finding that it was a timely filing, right? I mean, the finding is clearly that it was an untimely filing, and that it was untimely to the max, that, so that we got the maximum penalty under the statute of $1,500, and that the respondent paid. And so, as I, pejoratively, and Mr. Meyer would probably take issue with me, but as I pejoratively interpret his argument, it's she's done her time. She's paid her fine, she's done her time. Case is over. Why is that wrong?
It's wrong because these are the types of cases, just like with Davis, how I'm bringing it up to analyze why this should be found, or why she should make the same ruling that you made in Davis. We're going to look at this to see what we should do later. Other filers are going to look to see what we should do later. We want to make sure that whatever order that's issued by this commission is accurate and correct. So while I understand that it may not affect Ms. Miller Anderson's case, this will affect cases that come before you and go before the courts. So you want to make sure that the answers or that the information in these orders that you issue are legally sound and correct.
Isn't the ultimate goal of the commission that the filers file?
Timely file.
Well, of course. But that if they haven't timely filed, that they file. I mean, that, eventually it's filed.
The issue.
I mean, isn't that what ultimately gets them out of being removed from public office?
Of the elements that go along with saying that you can be removed from office, we include whether you receive notice. If the person had timely filed prior to November 1st, prior to the 1500, we wouldn't even be here. However, because that person did not timely file, because that person assessed the 1500, because they were in office, then the commission had to investigate the case. So ultimately, yes, the person did file, but that defeats the purpose of the timely filing, which It's what the public is supposed to be able to have in a timely manner to be able to assess how it feels about its public officials, be it they're supposed to be able to find out if there are any conflicts of interest. They're supposed to be able to make a determination about whether, in this case with a public official, whether they want to reelect that person or not. So it needs to be timely to go along with each year. 2015 is supposed to be filed in 2016, not 2017 like it was here.
Of course, I would never argue otherwise or suggest otherwise, but I guess what I'm trying to understand with respect to your argument is aren't these by the legislature parsed, that there's timely filing and there's a penalty for untimely filing, and then there's a penalty for not filing at all, and a requirement that it have a determination that it is willfully, that just absolutely I'm not going to disclose my financial.
And that's what I got to a little bit earlier. I don't think that there's just one particular statute that goes along with timely, or one statute that goes along with someone who didn't file at all. As I stated earlier, someone could, while you have the timely where it's $25 a day, you also have where someone can file a complaint. That leads to other penalties. That leads to public censure and reprimand. That can lead to a $10,000 violation. So I don't think that one statute goes with timely and one statute goes with someone who doesn't file at all. There are multiple statutes that a filer can violate. So it's not just $25 a day for timely or untimely.
Any other questions? Commissioner Brady?
Yeah, because, again, so if I understand the willfulness, is that what we're saying is that if you use a different, I guess, reckless disregard, we have a very different standard to have to meet to say somebody did it willfully than currently we simply track their behavior in terms of notices and a lack of reasonable information about whether or not they actually got the notices. And we at this point believe it's, if I'm wrong, please correct me, we believe it's willingly when we send them all this stuff and they simply ignore it.
Well, under Davis, what you've already previously ruled, then you said it was a reckless disregard. Similar in Davis, he got the notices and he didn't file. Here, you have an ALJ who, while Davis had already been ruled upon by a different ALJ, decided to use a different definition. And as I stated earlier, you already have case law that says that this agency has the discretion to rule on its own statutes and make an interpretation of the law under its own statutes, which you did in Davis.
And so if there's not an exception, then hypothetically we need to interpret willfulness differently than we currently do.
Well, if you don't accept this exception, if you don't agree with it, then you're going to have two different rulings on willful.
Okay.
In your exceptions as drafted, as I see, you have a lot of language with lines through it that's stricken. That's from the court's exact language, and then you have some language that's in bold. Is that added by yourself or your exceptions? So, for example, paragraph 39, you have about 3 sentences that are in bold, and then I have to go up. In paragraph, section 1 and paragraph 34, you have 1 sentence in bold.
That is correct. For example, in paragraph 34, where you see the strikeouts, that means remove, and in bold, that means that's the recommendation of what to change.
So I guess my question is either to counsel or yourself, do we have the authority to add different language from the court's original ruling?
Through the chair, if I might, essentially what you have here is, of course, as you know, the ultimate victory is going to go to Mr. Meyer and his client because there's a factual finding that you cannot disturb under 120 that she did not act willfully. But the way the advocate's exceptions are postured and then the way that we propose a draft final order, what we're trying to do in the draft final order is just to basically go with the Davis standard and not necessarily go with the legal ruling here. So I think the commission can do whatever it wants to in terms of the legal standards and the conclusions of law modification, and we've tried to, give you a vehicle for that. But I think we don't want you to give away a tool that's in your toolbox. You have an administrative law judge in the Davis case who made a better ruling that's more useful to the prosecution and implementation of financial disclosure than you have in this case. And the commission adopted as its final order that earlier ruling in the Joel Davis case. So you have precedent of this commission that is much more useful going forward than if this matter was adopted in full. And so that's what the advocate and the draft final order is seeking to do, is to really keep a tool in your toolbox. Don't give something away prematurely. This is a fact-based decision in the main here. And it should not be enabled to be a vehicle to be some broader legal thing when the respondent is winning here. And so we're urging as staff as well as the advocate that you not give away this tool in your toolbox, because willful is not defined in the statute. And there's various definitions that you could find in dictionaries. You could find this, that, and the other in a case. You can find what was used in the Joel Davis case, which was in a recommended order, thoughtfully done by an administrative law judge, the same rank as the person that did this case, from the same agency, which this commission has adopted. And I don't think it would help the commission here to go against what it has recently adopted, which is a much more useful tool going forward in a prosecutorial sense than what would happen if you adopted this current recommended order in full. I hope I didn't deviate from your focus. Bring me back to it if I did.
And just to oversimplify for my purposes, striking language from the court is perfectly permissible. As far as adding language,
Well, under Chapter 120, if I might through the chair, under Chapter 120 is permissible for agencies to adjust conclusions of law in their final order as long as they articulate a reason for it and make a finding, as we have in the draft final order, that the commission's substitution of its legal reasoning is as or more reasonable than that the ALJ did. Now, you cannot touch a fact finding hardly ever. That's why she's going to walk. But in terms of the law, that is your province as long as it's articulated, and I think it would be adequately articulated if you adopt the draft final order as offered to you.
Hawks.
I feel like willfulness is kind of a spectrum, and you're pointing us to Davis, which is relatively recent, but there's got to be more out there. Was Davis the only time we stepped in and defined willfulness?
The Commission on Ethics doesn't have it. That's why we went to the Elections Commission. So right now there isn't the defined definition of willful under what the Ethics Commission has done. Under the statute.
It's the administrative law judge in this case cited to a Florida Elections Commission case, Fugate, right? And that's where the administrative law judge utilized to define willful versus utilizing the Davis case, which is a Commission on Ethics case. Right?
I saw that.
Isn't that right? I mean, it sort of boils down to that. It's referenced in paragraph 39 that you seek to amend. Right? Willfulness is a question of fact, and then there's a definition from Fugate: specific intent, bad purpose to violate, disregard the requirements of the law, versus your position, willful is best defined as gross indifference and reckless disregard to the requirements of law, citing Davis.
Okay.
Right?
Yes.
Any other questions from the commission? All right, seeing none. Thank you, Ms. Hadley. We are open for a motion.
I move to approve the final order and public report as presented by the applicant.
Any second?
I'll second that for discussion purposes.
Okay, so we have a motion by Commissioner Rosanka, seconded by Commissioner Brady. Discussion.
Just my general thoughts. I think on the first exception, I'm 100% on board. The way I read Paren C, you get the violation, $1,500 racks up, the investigation opens. I don't think you can cure that to save yourself being removed from public office. On the second point, like I said, I think willfulness is just a spectrum, and I think the exception 2 might be a little too broad to find willfulness, and I think the ALJ's recommended order in 39 is a little too narrow. I mean, it's a little hard to find with a bad purpose part of it. So I'd probably punt on exception 2, but I do recommend approving exception 1.
Thank you, Commissioner. Hunting on third down. All right, so any other discussion? Going once on discussion. Okay, no other discussion. We have, the motion is to accept the recommendation of the advocate and the memorandum and proposed final order in response. All in favor, please say aye.
Aye.
Any opposed? Motion carries. All right, we will next move on to item 7, consideration of advisory opinions. We have 3 advisory opinions on our agenda today. First case is 2709, which will be presented by Caroline Kleinke, and is our requester here? No? All right. So we will not have that person introduce themselves. So, Ms. Kleinke, would you proceed, please?
Commissioners, Caroline Kleinke, Commission Legal Staff. Opinion file number 2709 arose from an inquiry from the Assistant County Attorney in Osceola County on behalf of the Chairman of the Osceola County Commission. The County Commission is currently considering obtaining responses to an RFQ associated with the selection of a new waste removal services provider for their residential individuals located within the county. The chairman of the board, in his private capacity, is employed by a corporation entitled WCA Management Company, LP, which is a corporate subsidiary of WCA Waste Corporation, a national corporation with many, many subsidiaries. The chairman has further advised us that his job responsibilities with this subsidiary also involve acting as the marketing sales representative on behalf of and for WCA of Florida. The requester in his request has advised us that WCA of Florida has indicated a desire to bid in response to the RFQ once issued. And thus, given his relationship to WCA of Florida, he seeks guidance regarding conflicts of interest that may arise should WCA of Florida respond to the County Commission's RFP once issued, and should it be selected by the board as a vendor of the county. He further inquires about factual scenarios wherein such conflicts, should they arise, be negated. The facts set forth in this inquiry primarily implicate Section 112.313(7)A, governing conflicting employment and contractual relationships. It has 2 parts. The first part of the statute prohibits the chairman from having an employment or a contractual relationship with another public agency or business entity if the business entity or agency is subject to the regulation of or doing business with his public agency, the County Commission. In previous decisions, the Commission on Ethics has found that different corporate subsidiaries are separate business entities for the purposes of this conflicts of interest analysis. In accordance with these prior decisions, the draft opinion states that were WCA of Florida to engage in a contract for waste removal services with the county, no conflict of interest would be implicated under the first part of the statute, because the corporate subsidiary employing the member namely WC Management Company, is not the business entity which would be doing business with the county. However, the opinion goes on to further analyze the second part of the statute. And it provides that it would be implicated. The second part prohibits the commissioner from holding an employment or a contractual relationship which would create a continuing or frequently recurring conflict between his public duties and his private relationships, or would impede the full and faithful discharge of his public duties. Under the standards set forth by the 4th District Court of Appeal in Zurich versus State Commission on Ethics, this portion of the statute requires an examination of the officer's public duties together with a review of his private obligations to his private employer to determine whether the two are compatible, separate and distinct, or whether they coincide to create a situation which tempts dishonor. The draft opinion notes that the commissioner's position as a marketing sales representative on behalf of WCA of Florida creates an issue under the second part, where WCA of Florida to bid on the multi-year contract for waste removal services for the county, the ultimate selection of the service provider would fall on the individual requester's own agency, of which he serves as chairman. Should WCA of Florida be selected for the exclusive 10-year contract, the county commission would have ultimate authority with respect to this vendor and their performance under the exclusive 10-year contract. Therefore, the draft opinion recommends that a prohibited conflict would exist under the second part of the statute. However, the draft opinion goes on to advise that the conflict of interest under the second part of Section 112.3137A would be negated if the member ceases to have duties or ongoing job responsibilities for the corporate subsidiary, WCA of Florida, which would be doing business with Osceola County. Under such a scenario, it explains that the corporate subsidiary employing the member would not be the business entity doing business with the county, and he would have no continuing or frequently reoccurring conflicts because his entity with which he does business, or on behalf of whom he does business, would no longer be WCA of Florida. For these reasons, we come to the conclusions that are reached in this draft recommendation, and staff is available to answer any questions.
Commissioner Ankers has a question.
Ms. Klinke, is it as easy, although you can't do anything about it and we may not be able to do anything about it, for somebody to go create a new corporation online, a separate subsidiary, and all they've done is just create this shell, but technically one that's not contracting with the county, and then they are able to negate the conflict? Is that true?
This commission has analyzed that exact issue with particularity. We couch our previous opinions, of which there are myriad. I mean, truly there are many at this point. Recognizing the separateness of corporations based on the definition of business entity that's contained in Section 112.312, subsection 5, which in those analyses represents the separateness by definition of these entities in Florida. That is a corporate reality that has been promulgated, and we are bound. And so, although there is a narrow exception that has been analyzed, most recently in 94-5, for pure holding companies, where the corporate veil is pierced. It has to be a factual scenario of the ilk of which you're describing, where the only holdings or assets of that subsidiary are the subsidiaries themselves, and it's one unit, ostensibly. That's factually not the case here, and we made sure through inquiries with the requester that this is not a mere holding company. And factually, they've made representations to the effect that it's not.
Thanks.
Any other questions? Commissioner Brady?
So Waste Management of Florida is a wholly owned subsidiary of Waste Management nationwide.
Correct.
So if Waste Management nationally created another corporation and the requester became employed by that corporation, that subsidiary, so that you no longer have a relationship with the contracting, that would be okay?
Effectually, yes. The way that this corporate structure exists, there is the parent company, WCA. WCA has all of its employees in multiple states and under multiple subsidiaries employed by one company, WCA Management. That functions as their HR division. And there's a certain amount of fluidity with respect to an individual employee's responsibilities, which can be reassigned. Here, we encourage, given the possibility for a conflict of interest, that such an assignment be made prior to the RFQ being issued, or at the very least, the contract being engaged in. Because of the fluidity of that assignment, the requester believes that that is very feasible.
Any other questions? Seeing none, we'll entertain a motion on adoption of the draft opinion.
Move to approve advisory opinion file 2709.
Is there a second?
Second.
Okay, we have a motion and a second by Commissioners Rosanka and past Chairman Ankers, respectively. Any discussion? Mr. Brady, Commissioner Brady.
Since waste management doesn't do anything but waste management. I mean, it's not General Electric, or it has a rocket and a healthcare and this business, and so when you move from one part of the business to another part of the business, you really have a very different business. I mean, waste management collects waste, and irrespective of where you are inside of that corporate structure, you know, you're driven, if you are an appropriate employee, to make that successful, and would, in all likelihood, produce a conflict of interest in the event that there was a dispute between the county and waste management. And I just don't believe that you really can create enough distance in a wholly owned subsidiary that's in a single business that would really present the distance that you'd like to have in terms of the conflict. So I will vote against the opinion.
Any other discussion?
I just feel like saying in defense of the opinion, I mean, as Ms. Klinke called it, the corporate reality of our society and our structure of the law, I think, has created the situation. It's, I would just, faced with a similar situation, if I had a client in this situation, I would say, don't ask, just go online tonight, create the new LLC, and then you've created the distance necessary. But that's a function of the way that our law is set up corporately, and that's the limitations in which I think that we have to work in providing this advisory opinion.
Any other discussion? All right, seeing none, we'll proceed to a vote on the motion, which is to adopt the draft opinion by staff. All in favor, please say aye. Aye. Any opposed?
Nay.
One opposed. Motion carries. All right, thank you, Ms. Klinke. Our next item, 8 on our agenda. Oh, no, I'm sorry, excuse me. Rookie chair. Okay, conflict of interest number 2722. Let's see here. All right, Mr. Schaefer is going to present our advisory opinion on that. Is the requester here for this case? No. All right. State University employee serving as Deputy Secretary for Health at the Department of Health. Mr. Schaefer, please proceed.
Thank you, Chair. Commissioners, this opinion request concerns a professor at the FSU Med School. He's performing some extra responsibilities at the Department of Health. Apparently, the position of Deputy Secretary for Health at DOH was unfilled, and so they needed to find someone who could fill that slot just temporarily. So the department reached out to FSU, and they entered into an arrangement just between those two agencies, whereby this professor would, in addition to his duties to FSU, perform extra responsibilities of the Deputy Secretary of Health at the Department of Health for about 8 to 10 months. Now, the professor was not a party to the agreement. It was strictly between FSU and DOH, and he's not collecting a paycheck or receiving any consideration from DOH. He remains a full-time FSU employee. He's just performing some duties at DOH until that Deputy Secretary position can be filled. Now, he's requesting his opinion, though, because some of the programs he oversees at FSU receive grant money from DOH. In particular, they receive grant money from some DOH programs like the tobacco program and the cancer program that are going to fall under his responsibility as the Deputy Secretary for Health. Now, he's been very clear that at FSU, he has no day-to-day role in supervising any of the FSU programs that receive the grant money, and he's not going to be applying for any of the grant money on FSU's behalf from DOH. And in his capacity as the temporary Deputy Secretary for Health, he's been clear that he has no day-to-day role in the programs dispersing those funds, and he does not review or approve grant applications. Still, there's an overlap between the programs he supervises and his capacities at FSU and DOH, and he's wondering if that presents any conflict under the Code of Ethics. Now, the statute most relevant to his inquiry, which Caroline already told you about, is Section 112.313, subsection 7, the Conflict of Interest statute. Now, as she said, that statute applies when a public employee like this FSU professor has some type of outside employment or contractual relationship that could conflict with his public duties. Now, given the very unique circumstances we have presented here, the draft recommends you find that this employee, this professor, does not have an outside employment or contractual relationship that will trigger that statute at all. Now, in the past, when it comes to employment, you all found that an employment relationship requires compensation or some form of consideration from the outside employer. This professor is performing the duties of the Deputy Secretary for Health temporarily at DOH, but he isn't collecting a paycheck or any consideration from DOH. He's been very clear he remains a full-time FSU employee, and all of his compensation comes from FSU. He collects no W-2 from the Department of Health. And while the Department of Health is reimbursing FSU for his time, it's not paying him personally. I'm not sure if this is in the draft, but he told me over the phone that when he took on those extra responsibilities as a Deputy Secretary, his salary remained the same at FSU. It hasn't changed. And regarding contractual relationships, he's been very clear. He was not a party to the arrangement between FSU and DOH. It was just between those two agencies, and he has no other contractual ties to DOH. So this is a very unique case where it doesn't appear we have the outside employment or contractual relationship needed to trigger the statute. So the draft recommends you find that this professor's service as the temporary Deputy Secretary for Health doesn't trigger Section 112.313, subsection 7. I'm submitting a draft to you now, and I'm happy to answer any of your questions.
Commissioners, do we have any questions for Mr. Schaefer?
I move the adoption of the draft opinion.
Second.
We have a motion and a second by Commissioner Hawks. Any discussion? Seeing none, all in favor, please say aye. Any opposed? Motion carries. Thank you, Mr. Schaefer. Our next advisory opinion case is file 2723 on voting conflicts. Ms. Klinke, I believe you're up again.
File number 2723 arose from an inquiry from the City Attorney of Punta Gorda on behalf of the Mayor, who also sits on the City Council. The City Council is currently considering an amendment to the city's land development regulations as they pertain to the Punta Gorda City Center zoning district. The proposed amendments would provide for minimum lot area requirements, minimum setback requirements, and a maximum height requirement for buildings located within the city center district. If approved, the proposed amendments would allow all buildings that meet certain requirements located within the city center district to exceed the current maximum height requirement by 6 feet. In her private capacity, the requester, together with her spouse, have an ownership interest in 6 lots located in the city center zoning district. In light of the impending votes or measures by the city council, the requester has asked whether she must abstain or otherwise comply with the voting conflict statute set forth in section 112.31433A with respect to the amendments to the land development regulations. Section 112.3143, the voting conflict statute, requires abstention from voting and certain other actions with respect to measures which would inure to the special private gain or loss of the public officer, to that of their relative, or to that of persons or entities standing in a relationship as described by the statute. The definition of special private gain or loss set forth in section 1D of the statute recognizes in part that a gain or loss from a vote or measure will not be special and thus will not give rise to a voting conflict when a sufficiently large class is affected, and asks the commission to analyze the degree to which the officer or his or her relative could receive a greater benefit or harm as compared to other members of that class. As set forth in the draft opinion in the instant manner, we recommend that the requester and her husband, because they own only 6 lots comprising only 0.65 acres located within the affected area, an area which contains 690 total lots and 134 total acres of developable land. Thus, the opinion notes that the official's ownership interest represents less than 1% of the total number of lots and less than 0.5% of the total developable land. Moreover, the facts in the instant case indicate that the proposed amendments will not result in any unique impact or disproportionate impact to the 6 vacant lots owned by the requester and her husband. Therefore, under these circumstances, the draft opinion provides that the proposed amendments to the city's land development regulations relating to the city center zoning district will not inure to the special private gain of the mayor nor that of her relative husband. And thus, the measures involving these proposed amendments will not implicate the requirements of the voting conflict statute, nor will it require her abstention. Staff is available to answer any questions you might have.
Thank you, Ms. Klenke. Ms. Fulford, I neglected to ask if our petitioner was here on this matter, but I'm under the impression that she is not. All right, thank you for confirming that for us. Okay, commissioners, do we have any questions for Ms. Klenke? Commissioner Anchors.
Mine is just procedural, not substantive, and I'm interested in this case and then maybe how this applies in other situations when an elected official asks a question about a prospective vote that presumably would have occurred already had they not asked for this advisory opinion. And it looks like, I may not have followed the timing precisely, she made an inquiry to which we responded, and then it was followed up with another request by the city attorney, and then 3 months later, they're getting a formal opinion. Can you tell us anything that would be enlightening about that sequence of events?
Absolutely. This is an instance, which is anomalous, but it occurs from time to time, wherein we had the requester herself, as an individual public officer, initially approach us. She gave us an array of facts which under our multifaceted statutory analysis of special private gain or loss implicated multiple aspects of the statute for scrutiny, many of which indicated that there was not a conflict, but some of which, in the context of an informal written analysis, indicated that perhaps there was. Subsequent to that inquiry, we issued an informal written analysis based on previous advisory opinions that had been published and issued. That medium is designed to give the most cautious advice in order to mitigate any liability in the form of a complaint. And that opinion, written by myself, advised in an abundance of caution, given, for example, her husband owns a construction company, of which he is part owner with his father. And it is the construction company itself that owns some of these platted lots. That was something that was front and center with respect to the initial informal inquiry. And it gave us pause. And for the reasons elucidated in that analysis, which are provided in your support materials, we recommended that the person abstain and comply with the voting conflict statute to ensure a full mitigation of any specter, given the ownership interest and the measures resulting in an undeniable economic benefit of 6 additional feet of building height, and which would apply to these 6 lots. In the subsequent days, the city attorney expressed angst with regard to the opinion, and he subsequently expressed a desire to request a formal opinion for your consideration. He was the author of the second opinion request, which was refined in its factual underpinnings. And
He asked a better question for
yes,
her.
Yes. He streamlined the inquiry itself. And as a result of that, which is the basis of this analysis and the posture which we find ourselves in, he took great pains to mitigate and highlight things to the benefit of his requester, which clearly indicate, based on the size of the class, for example, that he really underscored the totality of the impact being borne by every potential lot, the vacantness of the lots involved herein. It, in a multifaceted analysis, really underscored the aspects of the voting conflict statute that indicate that there is not a voting conflict.
But
We wanted to give you the full picture of what has transpired.
Right, and you obviously feel like those two opinions can be reconciled based on the questions and the facts that were presented in each of them.
Indeed. And we have a whole host of prior advisory opinions with respect to this analysis, analyzing with particularity the standard. And this opinion that's before you today in draft form does absolutely comport with the reasoning that's elucidated when we have previously said there is no voting conflict.
May I make one more comment?
Of course.
This is not a question, this is just a comment, but you could see how this person's vote might be critical to the ultimate outcome on what they're considering and why they went to such lengths to re-ask the question and perhaps delay the vote. And so it's worthy of looking, I think, at the history of how we got to render this opinion today, although I think that the question and the answer are correct.
Any other questions for Ms. Kling?
If I didn't already, I move the adoption of the draft opinion.
Okay, we have a motion for adoption of draft opinion. Any second? Thank you, Commissioner Rosanko. We have a second. Any further discussion? Seeing none, all in favor of adoption of the draft opinion, please say aye. Aye. Any opposed? Motion carries. All right, it is 10:05. If the executive director deems it appropriate, I'm thinking maybe since we've gone an hour and a half, we'll take a quick break. We have a hearing coming up on item 8, and so not sure exactly how long that'll go. So why don't we break until 10:15 and return promptly, please. I'll be. The only appeal for which a hearing has been requested is appeal number 2017-34. Craig Swain. Is Mr. Swain or counsel present? They are not. All right. So Do the members need to hear from Mr. Anderson, or is there a motion with respect to this hearing?
Second.
We have a motion and a second by, I'll give Commissioner Brady the credit for this one, since he's been less busy in that regard earlier in the proceedings. So thank you, Commissioner Brady. All in favor of the motion to accept the recommendation, please say aye. Aye. Any opposed? Seeing none, motion carries. All right, we now move on to the remainder. After we hear from Mr. Anderson on the staff recommendation, we will hear from, that was on the prior one, the meeting procedures. We have recommendations with respect to these other hearings. Are there a motion for them on no hearings, with no hearing?
Move to accept all as recommended by staff.
It is a long list. All right.
Second.
There is a second. All in favor?
Aye.
Any opposed? Thank you. All right. Our next matter, item 9, final order on financial disclosure fines where there has been no appeal and no payment. Item 9 on the agenda involves persons whose disclosure statements were filed late or not filed at all and who did not appeal the assessed fine or pay the fine. These cases are before you for the adoption of final orders imposing the fines. Are there any questions from the members? Seeing none, do I hear a motion?
Move to adopt the final orders as recommended by staff.
Second.
We have a motion and a second. Any discussion? Seeing none, all in favor?
Aye.
Any opposed? Motion carries. Wow, we are moving along. This is starting to make me look like Chairman Ankers. This is fantastic. All right.
It would have been 9:45.
All right, exactly. They'll be held to that later, but all right. So item 10, uncollectible fines. On the agenda for item 10 is a financial disclosure fine case where, after a final order imposing the fine, is recommended that we declare the fine uncollectible in this case because of the death of the filer. Are there any questions from the members?
Motion.
We have a motion to approve.
Second.
And a second. Any discussion? All in favor, please say aye.
Aye.
Any opposed? Motion carries. All right, item 11, consideration of proposed meeting calendar. Our lovely and talented Executive Director, Berlindia Dawes, shall suggest our meeting calendar, please.
This is just our annual adoption of our meeting calendars and deadlines for the upcoming year. I haven't heard any concerns expressed for conflicts or issues with any commission members, so if it's your pleasure, this, as I say, is pretty routine to just adopt for the upcoming year.
Move to approve the meeting schedule.
Second.
We have a motion and a second. Any discussion? Last chance to claim a conflict. Seeing none, all in favor, please say aye. Aye. Any opposed? Seeing none, motion carries. Rule adoption hearings. Okay, adoption of proposed commission rules. We have noticed for today a public hearing on changes to Rule Chapter 34-8, which governs our financial disclosure forms. The purpose of a public hearing is to allow the commission to hear public comment, evidence, and argument about the proposed changes. Following the hearing, the commission will decide whether to make any changes in response to public comments or written materials received, or whether to adopt the rule as noticed. The commission may withdraw a rule in whole or in part, or may make such changes as are supported by the record of the public hearing or any written materials we have received. The commission may also make technical changes which do not affect the substance of the rule. I'll ask Ms. Dawes to explain the changes to Chapter 34-8, and then we will proceed with the public hearing, deliberation, and vote. Ms. Dawes?
Commissioners, this is about the simplest rule package we've passed in a long, or we've had in a long time. This simply changes the dates on our financial disclosure forms for the upcoming year.
Commissioner Rosanka?
Why don't we put the email address on these where they can be filed by email?
I thought we
Did you? Okay.
Hang on. I'm wrong sometimes, so let me check. Yes, it is. You might be looking at the Form 6. Those can't be filed by email, only the Form 1s.
Okay.
So we have it on the Form 1s.
Thank you.
And we've been very successful with that. I expect that next year we'll get most of our Form 1s via email.
Okay, well, we will now declare our public hearing open on this important matter. So is there anyone from the public that would like to speak to our change of the dates? Seeing none, I will ask, we'll close the public hearing and ask, is there anyone else with respect to the commission that wishes to discuss on this issue? Seeing none, all in favor? Or we need a motion, I'm sorry, a motion.
Move to approve the regulation as presented at the public hearing.
And a second, keeping the chair from being a dictator, excellent. All right, all in favor,
Can I ask a
please.
question?
Of course, we're far beyond that now, but since you are the past
The motion
chairman,
was just
yes,
made.
we'll let you do that now.
Ms. Dawes, I noticed on Form 1, page 3, or the filing instructions for that, it was highlighted that we are addressing and including the Pinellas County Construction Licensing Board. Is that a new?
I beg your pardon, yes, I'm sorry, through the chair. That is a new group that was added in the last legislative session, so I should have mentioned that. We listed that on there specifically because it was added in the 2018 legislative session.
Thanks.
Thank you very much for that clarification. I will offer another opportunity for the public to speak to that issue if necessary. Seeing no one jumping up to do so, we'll return to where we were. We have a motion and a second. All in favor? Please say aye.
Aye.
Any opposed? Motion carries. All right. Next item, I believe, Madam Executive Director, is our reports. The chairman has no written report. I will offer this, I guess, as a oral report. Thank you very much to the commission for electing me as the chair. I'm happy to serve and honored to serve, and I appreciate that very much. I again want to thank Commissioner Akers for her great service. And we had our vice chairman has now moved on from our elections commissioner, Michael Cox, and he certainly was an outstanding commissioner and did a great job for our commission, and his service should be recognized. And we also have that a change in welcoming Commissioner Hawks. Very glad to have you with us. That involves some changeover with respect to our Commissioner Matt Carson going off of the board, and we greatly appreciate and want to acknowledge his service as well during his time. It was outstanding. And other than that, Madam Executive Director.
I have only two things on the Executive Director's report. You will not see Javoni Roberts versus Commission on Ethics on the next Executive Director's report because we got a very nice order from the judge in that case, and the Commission prevailed, unsurprisingly, because Betsy Daly was handling that, and she has done an outstanding job on these cases. The other thing I wanted to mention is with respect to our legislative efforts, with the loss of Commissioners Carson and Cox, our legislative committee has been a little bit decimated, I guess would be a word, but we still have Commissioner Brady, and I think that, at least for the time being, I think that that's really sufficient. In the House and Senate, they don't know exactly who's going to be there after the elections. They don't know what the priorities are going to be. We've made a lot of outreach to them, and we're in conversations with them, but there's not really a whole lot they can tell us at this moment anyway. So I'm going to suggest that we just go ahead and I'll stay in contact with Commissioner Brady, and at some time, if we need, in the future, if we need to do something different in terms of a committee, then we can set that up. And, you know, if Commissioner Brady's not available, I think the chair would allow me to reach out to him and, you know, help me out with legislative issues. So that's just my proposal for the interim right now.
Very good. All right. Any other comments for the good of the order? Seeing none, I will entertain a motion to adjourn our public session.
So moved.
All right, moved and seconded. Any opposition? Seeing none, we are adjourned. We will move to our executive session promptly, and that requires clearing of the room.